Good afternoon, everyone, and welcome to Module 4 of the Practical Training Academy's Taxation Training Series. My name is Idris Mohammed, and I am the Chief Operating Officer of the TPTA. I'm standing in for my chairman, Tobena Orejikwe, today. And it's my pleasure to serve as your moderator for today's session on tax compliance, enforcement, and dispute resolution. For the past 3 days, the Practical Training Academy's Taxation Training Series has been held. And on behalf of the Practical Training Academy, I want to thank everyone that has joined us for the past 3 days and also joining us this afternoon. We are thrilled to have participants from across the country and beyond. Today's topic is timely and practical. As compliance, as tax enforcement continues to evolve, both legal practitioners and businesses are under increasing pressure to stay informed and prepared. Our goal today is to help bridge that gap, translating tax regulations into real-world applications and helping you to navigate disputes efficiently. We have assembled a stellar group of people, 2 great speakers today. And before we begin, just a quick reminder, some form of housekeeping. Participants in today's training will earn 1 CPD point from the NBA Institute of Continued Legal Education. And we also encourage you to subscribe to our growing YouTube channel at the Practical Training Academy on YouTube. This would enable you access previous modules and upcoming sessions. The link will be shared in the chat in this Zoom webinar. We're privileged to have today 2 leading experts on tax issues in Nigeria with us this afternoon. Our first facilitator is Mr. Olanrewaju M. Lasisi Phillips. Mr. Phillips is a distinguished legal practitioner and a tax law expert with extensive experience in tax adjudication, policy, and dispute resolution. He served as the chairman of the Tax Appeal Tribunal Legal Zone Panel 1 between the years of 2018 and 2024. Where he delivered several notable decisions and contributed to strengthening Nigeria's tax adjudicatory framework. He is a partner at the Law Gates, a tax advisory and support firm, and teaches taxation of oil and gas on the University of Lagos Executive Master's Program. His earlier career has spanned leadership roles in tax litigation and corporate practice, including serving as the practice head at ASCO LP and in-house counsel in major financial institutions. He is also the editor of the African Tax Law Report, Nigerian Revenue Law Report, All Nigerian Tax Cases, and has facilitated specialized training programs for federal tax authorities, the State Internal Revenue Services, and professional bodies such as CITN. He is the author of 2 influential books that have shaped the understanding of Nigerian tax adjudication and procedure. The books are The Nigerian Tax Appeal Succinctly Explained, published in 2024, and the first structured exposition. This was the first structured exposition on the country's tax appeal process. And Witness Examination at the Tax Tribunal, a former chairman's practical handbook, which was published this year. It is a practical guide to evidence and procedure before the tribunal. He has scholarly contributions, including widely cited articles on tribunal jurisdictions, standards of proof in tax disputes, and tax administration. Mr. Lasisi Phillips holds LLB and LLM degrees, tax law focus from the University of Lagos, and is currently pursuing a doctorate in tax law. Our second speaker is Dr. Jerome Okoro who is the managing partner of Tetralex Legal and Advisory. Dr. Okoro holds a PhD in Energy Law from the University of Ibadan with a dissertation on the development of oil and gas marginal fields in Nigeria, a Masters of Law LLM from the University of Lagos, and a Bachelor of Laws LLB second class upper from the prestigious University of Nigeria in Nsukka. He is presently the managing partner of Tetralex Legal and Advisory, a law firm based in Lagos, with specialization in legal litigation and advisory, commercial litigation, and energy law. Dr. Okoro's exceptional expertise in litigation, tax law, and energy law is founded on a rich practice experience from top-tier law firms and at the legal department of the Federal Inland Revenue Service, FIRS. At FIRS, he prosecuted several cases and got an impressive number of landmark judgments on intricate issues of tax generally and petroleum taxation in particular in favor of FIRS. He has won cases against some state revenue authorities and has saved taxpayers huge tax liabilities. Together, they will walk us through the critical aspects of tax compliance, enforcement, and dispute resolution, from preventive compliance strategies to resolving disputes efficiently and legally. You would agree with me that we are going to learn quite a bit from these stellar speakers. We're just trying to confirm if Mr. Lasisi Phillips is available so we can commence with him. Okay, I can see he's in the chat. So I would now call on Mr. Olanrewaju Lasisi Phillips, who would be focusing on, I've gone through a couple of his slides already, and it will be focusing on tax dispute management. Mr. Lasisi Phillips, sir, you have the floor. Mr. Lasisi, sir, please, you have the floor. Your slides are now ready. Please, sir, you can also switch on your cam. We seem to be having some problems with Mr. Lasisi joining us right now, but we'll continue to try and engage him to see so that he can join us as soon as possible. I've just been informed that Mr. Lasisi is having some problems with his network. So while we wait for that to be resolved, I would just crave the indulgence of all participants to give us a minute or two in order for us to sort out all the communication issues with Mr. Lasisi. Just a minute or two, please. Thank you.
Hello, good afternoon. Can you hear me now?
Sir, yes, sir, we can hear you.
We can hear you.
Yes, sir, we can hear you now, sir. Please, sir, go ahead. Thank you so much for joining.
All right. Good afternoon. Quickly, I'll be talking about tax dispute management. If you move to the next slide, please, you will see the progression of my flow of thought. Can we move to the next slide? Okay, so you can see the slide deck roadmap, my progression of thought. I intend to discuss dispute management under 4 basic heads, what I call the pre-action stage, dispute prevention, the ombudsman, and then of course the tax appeal tribunal. The session objectives are there. I wouldn't want to waste our time reading that out. We can look at it at our own convenience. Yes, so I would like to move to the sources of tax disputes. And when we say tax dispute, it has a technical meaning because not all tax disputes are tax disputes for the purpose of the tax appeal tribunal. There are some tax disputes that the tribunal can undo, which, yes, that must come to the tribunal as the first point of formal adjudication. And then there are those that only the Federal High Court can undo. It will be a misnomer to say that the ombudsman also undoes tax disputes. I know people often say that the ombudsman undoes tax disputes, but it doesn't. What the ombudsman undoes are issues of their complaints, and they border on service failure mainly. But in a general sense, when we talk about tax disputes, we are talking about issues relating to interpretation of tax, laws. Of course, the advanced tax ruling can also be a source of tax disputes. There has been a case like that came before my tribunal, and I think that's the case of Chi Limited and FRS, where the taxpayer wanted the tax authority to interpret a provision, which eventually was not to their favor, and then they came before the tribunal. And then tax dispute also can arise from tax audits. I'm sure we all understand what tax audits are. That's when the tax man pays you a visit to verify your filings. Since we run a system of self-assessment in this country. And then, of course, administrative assessment also can result in tax dispute, particularly where the taxpayer challenges the factual basis of the assessment, the assumptions, statutory foundation of the assessments. And then enforcement actions also can culminate in tax disputes. You can also have conflicting or conflict of a tax authority, and then you find that in the case, a prominent case is the case of Okala SAN and FIRS. Now, having established the sources, let's now move to the dispute resolution procedure designated under the Nigerian Tax Administration Act 2025, which is very similar to what we used to have under CITA, Section 69 of CITA. Basically, when an assessment is reached under the NTAA, the taxpayer may agree with that assessment, and then he may pay, and that will be the end of it. However, if he disagrees with the assessment, and of course, you know what an assessment is. An assessment is the formal determination by the tax authority of the taxpayer's liability specifying taxable income, deductions, allowances, and the final tax due for a given period. Okay, so if he does not agree or he disagrees with the assessment, Section 41(2)(a) requires the taxpayer to file immediately or within a period of 30 days a written objection. All right? The objection must state the grounds and must include relevant supporting documents. Can you hear me, please? Hello?
We can hear you clearly.
We hear you. Yes, sir, we can hear you clearly.
All right,
Please.
because I can see that the slide is still on the session objectives. I think we need to move to slide 7.
Okay. VAT.
Okay.
VAT, he has moved to slide 7 now, sir.
Okay, good.
Thank you, sir.
All right. Now, I said that the objection must state must state grounds, and then, there must be supporting documents that will go with it. 30 days is the period within which the taxpayer must object. However, in defined circumstances, the tax authority may, for valid reason, extend the time during which the objection may be made. Now, upon receipt, the tax authority must decide on the objection within 90 days. Previously, we don't have a statutory provision of this fashion. What we relied on was a decision of the tribunal, which prescribed 90 days as a reasonable time within which the tax authority must issue a notice of refusal to amend. Now, failure to respond within this period.
Sorry, sir. I'm sorry to interrupt you, sir. Sorry. I can see that you have logged in on 2 devices. Can you just log out on one of them so that we now have this echo? I'm so sorry to interrupt, sir. Thank you so much.
Hello.
Yes, sir. It's good now. Thank you.
It's good. Okay. So I was saying that previously, we did not have a statutory provision stipulating the time within which the tax authority must respond to an objection. But now we have 90 days under Section 41(6) of the NTAA. Now, failure to respond within this period means the objection will be deemed upheld. Unlike what we had previously, failure to respond was a deemed NORA. But now, if the tax authority refuses to respond within 90 days, then that means the objection of the taxpayer is deemed allowed and upheld. Now, where the objection is partly or wholly upheld, a revised assessment must be issued. However, where the tax authority disagrees, the law is silent on what should be done. What the law says is that if the tax authority disagrees, then the taxpayer can exercise his right of appeal. So which means that the document that we used to know as a notice of refusal to amend NORA may have been silently removed from the body of our laws. It's not expressly provided, but I want to assume that in practice, the tax authorities will continue to issue NORA because it used to be the final point. Of course, there were decisions that made it clear that you do not have to wait for NORA before you appeal to the tribunal. In fact, from the point that an assessment is raised, if that assessment is disagreeable, a taxpayer can actually appeal directly to the tax appeal tribunal. Okay? Yes. Now, failure to appeal within the statutory time renders the assessment final and conclusive, attracting applicable interest and penalties, so that when we are talking to our clients, we need to guide them appropriately. Of course, there is power in the tribunal, of course, to enlarge the time within which to appeal. We'll get to that as we go on. Now, note that the filing of a formal objection does not operate as a bar to instituting proceedings before the Tax Appeal Tribunal or the court. So I think I've mentioned that anyway. Service may be effected through any method capable of delivering the assessment or correspondence with the tax authority, including courier, electronic means, that different things, different ways that we can use. We are in the age of technology, so we can use that. From time the tribunal has held that service by email is valid, and you can see that in the case of Earth Moving International Limited against FIRS. Now, I mentioned that the objection must include certain facts. Must the grounds of the objection must be clear, must be specific. The ground must specify statutory or factual errors, including monetary impacts, amendments that you are seeking with justification, the assessable and total profits, the relevant transaction values as admitted, if any, or a full rejection of the assessment. You want to see section 41(2)(b) of the NTAA. The truth is that when you object, the tax authority may request further particulars, documents, information. They can even summon people to appear, to give, to testify in a fact-finding process, or invite the taxpayer to a reconciliation process, which oftentimes is called the TAC. Okay, so that is that about I call it the pre-action stage. But other people call it the objection and review stage. Of course, Section 141 of the NTAA also now expressly codified amicable resolution or settlement. It calls it settlement. So it says that parties can resolve their dispute at any point, at any stage. And this is not the same as what we just discussed, because settlement is actually broader. Settlement can take place even at the level of the Tax Appeal Tribunal when parties are, even at on appeal, parties can still decide to settle. The law says that the parties can actually do that. So you can have your settlement at any stage. However, it should be noted that settlement is encouraged in part or whole in two instances. One, where it is in the interest of public revenue or public policy. This includes scenarios where a negotiated outcome secures revenue more efficiently or aligns with fiscal or regulatory priorities. Secondly, it is also encouraged, where due consideration has been given to the cost of litigation in comparison to the potential benefits of pursuing the dispute. That is, where settlement provides a more efficient resolution. So, in those two instances, yes, settlement is encouraged. Additionally, it is also encouraged where a participant or a group of participants in a tax arrangement has accepted the position of the relevant tax authority in the dispute, in which case the settlement may be negotiated in the manner necessary to adjust the tax arrangement or disposition accordingly. And finally, under a whistleblowing arrangement, the settlement will facilitate full disclosure of undisclosed tax planning or tax evasion schemes that may lead to significant recovery of tax revenue. In other words, the tax authority may settle where incentivizing cooperation leads to a wider compliance gain. On the other hand, settlement is prohibited where the conduct of the taxable person leading to the dispute constitutes intentional tax evasion or fraud that is inimical to government revenue. Of course, you don't want to promote tax evasion intentional one. We don't want to promote that because that will discourage other taxpayers if they say that eventually a government enters into some sort of a settlement with such persons. It will also be prohibited if it is the public interest to obtain judicial clarification of the issue, or such clarification will significantly promote taxpayer compliance with the relevant tax law. So in those two instances, the exclusion ensures that settlement mechanisms are not used to legitimize deliberate tax evasion or to avoid necessary judicial guidance. All right. Now, when any settlement is reached, it must be documented in writing, issues resolved, and the agreed treatment for future years, relevant undertakings by both parties, withdrawals of objections or appeal. All of these things are what must be detailed when settlement is reached between the taxpayer and the tax authority. All right, so now we move to what I call dispute prevention, and it is what the law calls the tax advance ruling. Sorry, advanced tax ruling. It's advanced tax ruling, ATR. Now, an advanced tax ruling is a written interpretation issued by a tax authority before a transaction occurs, providing certainty on how tax law will apply to a particular transaction. And then you will find this in between section 77 and section 76 of the NTAA. Now, the good thing about ATR is that it enables taxpayers, especially professionals and entrepreneurs, to clarify obligations before filing returns. So when you have a client that wants to understand his tax exposure, particularly in an area that is complex, you can always approach, under this framework, approach the tax authority to give an opinion, which in a way will be binding on both of you as to the effect of that transaction. So you have an idea what exactly the tax exposure would be. So it's a risk minimizing tool. Okay. The ATR reduce post-assessment disputes and, of course, the cases that will go to the tribunal. Of course, because parties will have agreed on the tax treatment of, the transaction. So there will be no need. The possibility of disagreement is almost zero. Okay, it builds a partnership model between the tax authorities and taxpayers, advancing people-centered tax administration. It creates a repository of rulings that guide future audits and promotes uniform interpretation. Yes, while this will seem to be factual, the truth is that, the ruling is not binding on third parties. I think it's only binding on the specific parties, that is the tax authority and the particular taxpayer. And that is, in my view, one of the shortfalls of the ATR, but then it's still a viable dispute prevention mechanism if it is properly used. The procedure is stated there succinctly. You apply for a ruling on a proposed transaction. The ruling is specific to a defined taxpayer and the desired transaction. The tax authority has a 21-day window to respond, promoting efficiency. It can be voided by material facts, material fact changes, misrepresentation, or subsequent changes in law. And of course, yes, if the ruling is not satisfactory, parties can always appeal to the tribunal. I'm not sure that it precludes the power of the tribunal or the powers of the court from looking into the ruling that has been given by the tax authority. In the past, it has been said that even legitimate expectation. I'm sure we remember a few cases on legitimate expectations and what the courts have held in respect of that. so that in a way, even when the tax authority has given a ruling, they may turn back for some reason and change their mind. I hope that will not be the case with the ATR. I'm sure that with time, specific regulations will be released as to how the ATR particularly will be operationalized. Because what we have right now is still the general framework. Okay, so let's move to the tax ombud. And I say the tax ombud is the first stop for administrative grievances. I said at the beginning that the tax ombud does not resolve tax disputes. We must not make that mistake. Tax disputes are essentially matters that only the tribunal or the courts can adjudicate upon. However, the tax ombud will play a prominent role, I believe, in the tax system. It is established under Section 36 of the Joint Revenue Board of Nigeria Establishment Act, the JRBEA, as a low-cost, fast-track mechanism to resolve procedural frustrations without formal litigation. That's the way I describe it. So its role is that of an independent and an impartial body to handle complaints about administrative failings by the tax authority. So it's a watchman or a watchdog over the tax authorities, mostly. The jurisdiction of the tax ombud is found in Section 41 of the JRBA, encompassing investigating maladministration, mediating disputes in quotes, informally, inspecting tax authorities' premises, recommending corrective measures, and initiating legal proceedings on behalf of taxpayers. I think that's a good one. They will be able to, for indigent taxpayers who really have genuine cases, it will then seem that there is some sort of funding of tax dispute litigation by government. We also need to understand that the services of the tax ombud is free, is at no cost to anybody. All right. Now, what can the tax ombud, what issues can it address? I listed about 4 of them here. Yes, unreasonable delays in processing refunds or TCC. So you don't need to come to the tribunal for such matters. I think administratively, this can be handled when you go before the tax ombud. Discussions on professional behavior by tax authority staff, failure to follow published procedures or their guidelines. I know, for instance, that the NRS or the FRS has a service charter, which also has detailed inside it the rights and of taxpayers and the obligations and responsibilities of the tax authority. So we should all we should get a copy of that so that we know what their procedures and guidelines are to see whether they actually follow those things. And if they don't, then you can approach the tax ombud on these issues. Then issues of systemic service failures also are issues that the tax ombud can handle. Number Section 43 of the JRBEA, the tax ombud is explicitly excludes from interpreting tax laws or determining tax liabilities. These carefully circumscribe the mandate of the tax ombud, so that it is clear that the role of the tax ombud really is it's complementary. It does not conflict with the role of the TAT and the judiciary. All right. Now, there are some things that the tax ombud cannot address. There are certain issues that you cannot take before the tax ombud. Of course, in a way, I've mentioned one, disputes about the interpretation of tax laws or the amount of tax assessed, matters already before the TAT or before the court, matters of staff of the tax authorities. They can't take their cases there to the tax ombud. We should note that the tax ombud's recommendations are non-binding. They rely on moral suasions and legislative oversight. If you want to see the procedure of the tax ombud, you should see the top schedule to the JROBEA. It details the procedure of the tax ombud, the filing of the complaint, as a preliminary to the filing. Of course, you must have engaged with the tax authority to see how you can resolve the matter amicably. It is only when that fails that you're supposed to, approach the tax ombud on these service, issues or procedural matters. And then, of course, they will scrutinize your complaint to see whether it falls within their mandate. If it is outside of their mandate, of course, they are going to advise you on the next steps that you should take, because they will not be able to address that. If it falls within their mandate, then they will have to break it down to see which aspect of their mandate it falls into. Of course, they can ask you for additional documents. And if they are not going to take up your matter, I think the law says that they have 7 days within which they should give you a reason why they will not be taking up your matter, and so on and so forth. So that is that about the tax ombud. We will now quickly move to the Tax Appeal Tribunal. Are we there? Hello?
Sir, we're with you, sir. Please carry on. But just to notify you that we have to end your own session by 3:50. That's 10 minutes to 4. So if we could, because we have another speaker.
Wow, my time is practically done. My God.
Just take your time, sir. Just take your time. But we have another speaker that is supposed to come up. Then after that, we go for Q&A.
Dr. Jerome?
Yes, sir.
Yeah, I know. Okay, so the Tax Appeal Tribunal, of course, is the formal precise judicial forum for the resolution of tax disputes. It's established under Section 29 of the JROBA with a wider jurisdiction. It now has power to adjudicate pure state tax dispute, provided that the State House of Assembly, by a law, confers jurisdiction on it. I will just put, because of the time, I'll quickly run through what I have here. The jurisdiction of the tribunal is impersonal. That is, it must be between a taxpayer and a tax authority. It's very important that we note that only a taxpayer and a tax authority have audience before the tribunal. The tribunal does not have criminal jurisdiction. It lacks that. The reliefs it can grant are also very limited. So if you look at paragraph 7.8, it gives you an idea of the kind of reliefs that the tribunal can grant. Now, the tribunal's jurisdiction is triggered when there is a disagreeable assessment, a disagreeable demand notice, action, the decision of the tax authority, or a dispute as to tax residency. This last trigger was introduced under the new framework. And then we need to differentiate, the tribunal's jurisdiction in residence matter from the one that is conferred on the Joint Revenue Board under Section 5B of the JROBEA. They are not the same. Okay. Quickly, let me just say that the burden of proof before the Tax Appeal Tribunal is not the same as the onus of proof that we find in the Evidence Act. And that's because under the Evidence Act, he who asserts must prove. But there is a reverse burden when it comes to the Tax Appeal Tribunal. When an assessment is raised by the tax authority, you should note that this is very important. When an assessment is raised by the tax authority, the law requires the taxpayer who did not raise it, who is not the one making an allegation, because, you can allege. You can allege, a statement can be an allegation, So the law requires the taxpayer to prove that that assessment is excessive. So the initial onus of proof is always on the taxpayer. I also want you to know, or want us to note, that the provisions of the Evidence Act are not mandatory. Yes, they apply, because when you look at the wordings of paragraph 8 of the second schedule to the GRBA, the way it is couched, you will see that it contemplates that the tribunal should, to a large extent, follow or adhere to the provisions of the Evidence Act. However, non-compliance, that's what the law says, non-compliance will not vitiate the proceedings or the decisions of the tribunal. So as much as possible, we should also try to apply the provisions of the Evidence Act. We should have that at the back of our mind. Okay. Just trying to pinpoint the very important things that we need to note in respect of the Tax Appeal Tribunal. All right. Then, you should know that there is a unique provision under the Nigerian law, and I think this is only applicable in Nigeria. A tax authority also can appeal before the tribunal. It can file an appeal before the tribunal. So when you look at paragraph 3 of the second schedule to the JRBA, you will see that the tax authority also can drag the taxpayers before the Tax Appeal Tribunal. The proceedings before the Tax Appeal Tribunals are adversarial. They mimic the proceedings in the regular court because they adopt a trial-like procedure. Yes, the tribunal is not constrained by pre-action notices or the application of the Public Officer Protection Law. These have been excluded expressly when you look at paragraph 12 of the second schedule. Some have argued that the fact that these provisions are in the second schedule, and that when you go back and look at the Nigeria Revenue Service Establishment Act, which provides which provides that no proceeding should be commenced without fulfilling the requirement of the Public Officer Protection Law and satisfying the reaction and notice protocols. But for that reason, it will be important or necessary that parties will have to comply. My position is that we should understand that tax appeal is sui generis, is a special procedure, and the provisions that we are dealing with are special provisions. So therefore, the general provisions that you find in the Nigerian Revenue Service Establishment, Act will not, override what is contained in this special proceeding. In my view, I may be wrong, but I think that's the position. Okay. Yes. Pleadings and processes. The originating processes before the tribunal is the notice of appeal. That's the originating process. It sounds like a statement of claim for the appellant. So even though we call it a notice of appeal, you should think of it like a statement of claim, because it contains your factual statements and it details all the things that have led to the dispute. So all the rules that with respect to preparing your statement of claim, you should bring them to play here. All right. Yes. That's basically the originating process, and then you have other non-originating processes. For instance, the reply to the notice of appeal. That is how the respondent enters appearance before the tribunal. I'm sure it's not going to change We don't know what will happen to the rules of the tribunal, or whether the current rules will be retained or a new rule will come into play. But under the dispensation in which we serve, the law was very clear that you enter appearance by filing your respondent's reply. I remember somebody, a counsel would appear before the tribunal, and then she filed a memorandum of conditional appearance. And then we had to quietly and tactfully inform her that there is no such process known to the Tax Appeal Tribunal. You don't enter appearance in that fashion. You enter appearance by filing the reply to the notice of appeal. Generally, the appellant is also allowed to file a rejoinder, even though it is not expressly provided, but it has become the practice of the tribunal that an appellant can file a rejoinder where that is deemed necessary. There are currently 6 hearing methods that by which an appeal can be heard. You have the standard trial, that is the full oral hearing with co-examination and all of that, the proper adversarial hearing process. Then you have the documents only, where written submissions are made, no oral testimony. You have the case stated, where parties can refer legal question to the tribunal for interpretation. We have the summary appeal procedure for recovery of liquidated debts. And then the second schedule, the JRBA, in the second schedule, introduced 2 additional hearing methods, very similar to some of the ones that we have discussed. We have appeal by summons, which is also used when the appeal raises only questions of interpretation, when facts are not in dispute and affidavit evidence will be sufficient. Then there is the liquidated money claim, which is for simple recovery of specific monetary sum. So you find that we don't know how it will pan out eventually, particularly since these hearing procedures are contained in the substantive legislation. I want to believe that, going by the rules and the principle of hierarchy of authorities, the fact that they are contained in principal legislation means that they will override the hearing procedure prescribed under the TAT rules. But we don't know how that will pan out, so we'll wait and see how the tribunal will treat this issue, what information that they will eventually release. Perhaps maybe the TAT rules might be updated. So let's quickly just go to the tribunal's procedure initiation. The notice of appeal is filed within 30 days of the decision being appealed, or the action that is being appealed at any zone of the TAT. However, you must properly head the notice of appeal. So, for instance, because the tribunal is located in all the geopolitical zones, and there is a standalone tribunal in Lagos and another one in Abuja. So, for instance, you may have your appeal in Lagos, but probably you are currently in Abuja. You can file at Abuja, but you properly edit so that it is clear that the appeal is to be heard in Lagos. If the time frame is, if you do not file within the 30-day window, you can apply for an extension of time. Of course, when you file, you must ensure that you file the number, appropriate, or the required number of copies of the appeal document, having regard to the size of the hearing panel. Then you may want to nominate a preferred hearing method. I've mentioned the 6, so you may want to nominate one as early as possible. All your documents, necessary documents, must be front-loaded. Documents that support the appeal, and then the prescribed fees must be paid. Now, once that is done, the tribunal secretary will assign an appeal number to the case. This number and the originating appeal document will be served on the respondent. The respondent has 30 days from the date of service to enter appearance by filing a respondent reply to Notice of Appeal. See the case of Tourist Company of Nigeria PLC and FIRS. This reply must clearly state the reasons for contesting the appeal and include all their prescribed front-loaded documents as well. If the respondent fails to file a reply within the times stipulated, or having filed a reply, subsequently abscond from the hearing, we have seen cases like that, a default judgment is entered against them. If the respondent files their reply late, they must apply to the tribunal for an enlargement of time to enter appearance, in which case, in this context, like I said, it involves filing of respondent's reply. See the case again of a Tourist Company of Nigeria PLC and FRS Supra. The tribunal secretary will then serve the respondent reply on the appellant, just the same way that we do in the regular court. Now, why not explicitly provided for in the dispute framework? The appellant may, with the tribunal's permission, file a rejoinder. I mentioned that earlier, to the respondent reply, further clarifying their position. A formal application to regularize the filing of the rejoinder is usually required if filed outside the time limited by the tribunal. Once the parties have filed their initial documents and issues joined, the tribunal will typically set a date, a trial date, subject to any interlocutory applications, requests for specific actions or applications for adjournment, postponement, the parties may file, maybe application for to amend and all of that. Then, of course, parties are always, allowed to explore potential resolution. The tribunal on its own too may initiate settlement process, looking at the documents filed by the parties. Parties on their own too can jointly request time to pursue reconciliation or settlement. It is now in the law that the tribunal may allow parties to explore amicable resolution. It is contained now in paragraph 6 of the second schedule to the JROBEA. Trial procedure generally follow the procedure of the High Court. Hearing can be conducted in person or virtually, remotely. The appellant open their case first, calling their witnesses, and then they go through all of that. They call their witnesses, who will adopt their sworn statements, tender documents as exhibits, and are subject to pro-examination by the respondent counsel. They may be re-examined if necessary. The respondent then present their case, they go through the same motion. Unless parties seek to reopen their case with the tribunal's permission, the trial concludes after the testimony of the respondent last witness. The tribunal will then direct parties to file final written addresses, then potentially a reply on points of law. The reply on points of law is not expressly provided in the rules of the tribunal, but like I said, it has become the practice of the tribunal. The standard time frame is typically 21 days for final written addresses and 7 days for reply. If the respondent presented evidence, they file their final address first. Now, if the appeal is to be determined based on documents alone or case stated, the appellant will then file their address first. A prior report of law also may be allowed in appropriate instances, particularly if the appellant makes a request for it. Yes, this is set for parties to adopt their final addresses. In appropriate instances, the addresses may be deemed adopted even if a party is absent. The appeal is then adjourned for judgment, which is usually delivered within 90 days, consistent with the constitutional provisions. Judgment, save a consent judgment, must contain a statement of the tribunal's reasoning for its decision. Now, note that it is sufficient if the judgment is signed by the chairman alone. It has been held that inconsistent participation by a member may vitiate the entire proceedings. You want to see the case of Dauda, Joseph Dauda, SN, and FRS. Conflict of interest may also vitiate TAT proceedings. A tribunal member with prior involvement in a tax audit raises a reasonable apprehension of bias, which will invalidate the decision, even if the assessment is correct. You want to see the case of Abuja Electricity Distribution Company, PLC, against FIRS. Now, once the tribunal gives its judgment, it becomes functus official. We all know that. However, there are instances where the tribunal can still go back and look at its judgment, where the necessary application is made. There are defined circumstances which empower the tribunal to visit its judgment after delivery. Enforcement of judgment, to enforce it, the tribunal's judgment, it must be registered with the chief registrar of the relevant high court. I want to look at paragraph 9.2 of the second schedule. The high courts now, I'm talking about state high courts, I think they need to now have their own framework for the enforcement of the tribunal's judgment in view of the fact that appeal will now lie, or that a two-part appeal process will evolve going forward. Appeal to higher court, yes, any party dissatisfied with the tribunal's decision may appeal to the relevant high court, but only on points of law, paragraph 10.1 of the second schedule. And then from the high court, they can appeal further to the Court of Appeal, and then to the Supreme Court. You want to look at section 41.8 of the NTAA. Application to stay judgment may also be filed to forestall enforcement pending appeal. There are special considerations here that I have listed. Withdrawal of appeals, the appellant can withdraw the appeal at any time during the hearing. Appeals also can be struck out. The tribunal also has power to strike it out on its own motion in appropriate instances. Any default judgment entered can be set aside where an application is brought within the time defined in the rules. The tribunal may award costs against any party. That's something that was introduced under the 2021 rules. However, it should be noted that each party generally will bear their own cost for prosecuting or defending the appeal. The cost that the tribunal usually will award will be for wasting the time of the tribunal. But the cost for prosecuting the appeal, the cost will be borne by the parties. Yes, when any application is granted, the tribunal has power to impose certain conditions and times. So we need to note that when a matter has gone on appeal to the High Court and even beyond, we should know that they enjoy priority. If you look at Section 34 of the Federal High Court Act, for instance, it enjoys judges to give priority to cases concerning the revenue of the federal government, whether that court is sitting in its original or appellate jurisdiction. Conclusion: Nigeria's tax dispute management framework under the NTAA and GRBA is a structured, time-sensitive, and legally rigorous system designed to balance administrative fairness with judicial oversight. The TAT remains the central judicial forum, and mastery of its procedure is critical for effective tax advocacy. Alternative mechanisms, amicable settlement, advanced ruling, and the tax ombud, they provide front-end tools that reduce dispute escalation and enhance taxpayer confidence. But we need to know that effective representation demands not only doctrinal knowledge, but also procedural precision, strategic timing, and awareness of jurisdictional nuances. And there are different ones when it comes to the tribunal. Time does not allow us to look into all of these nuances, but we should, when we read further, we will see, and I encourage us to read further to stay updated with what is happening at the tribunal. Key takeaways: timelines are non-negotiable. Note that originating processes determine jurisdiction. The tribunal is flexible in form, but it is judicial in fairness, which means that a reverse burden of proof applies. Settlement is a powerful but limited tool. Case law guidance is very essential. You want to see the recent decisions of the tribunal and then even of the High Court, so that you can take lessons and see how they guide the orderly progression of the conduct of proceedings for the tribunal. I would advise us to just avoid procedural pitfalls. They can always tend to delay unnecessarily hearing. For us as lawyers, I think the next step is what I have stated there. We should review our internal client and our farm procedure to ensure compliance with the updated NTAA and JRBA frameworks, because there have been changes. In fact, the JRBA, in my view, from what I've seen, JRBA introduces about 20 modifications to what we currently have. So we need to update, our procedures. We need to conduct a procedural audit of ongoing and upcoming tax disputes to identify timeline risk or jurisdictional weaknesses. We must know the kind of matters that may be initiated before the Tax Appeal Tribunal. It's not all matters that you can bring for the Tax Appeal Tribunal. Once the private party disputes cannot be brought before the tribunal. Yes, criminal matters cannot be brought before the tribunal. That some matters like that the tribunal does not have to. So you must watch to be sure that there is a taxpayer and a tax authority involved, and the matter relates to a tax dispute that you can trace to a specific tax type or tax legislation. All right. Then you need to develop internal templates for objections. So have your own templates. Your notices of appeal, settlement document, case stated applications. Well, we don't know whether case stated will survive. We wait until next year to see what the tribunal will do, whether the current tax appeal procedure rules would survive, and all of that. And then you need to incorporate the tax ombud and ATR pathways into client advisory processes to reduce avoidable disputes. For additional resources, you may want to read the Nigerian Tax Administration Act 2025, the Joint Revenue Board of Nigeria Establishment Act 2025, the Tax Appeal Tribunal Procedure Rules. I'm sure even if the rules is amended, essentially a significant part of it will remain. I also recommend my book. If you want to read my book, Nigeria Tax Appeal Succinctly Explained, and then witness examination at the tax tribunal, they will provide you with further guidance on tax appeal or dispute resolution process in Nigeria. Thank you very much.
Thank you so much, Mr. Lasisi Phillips. This has been a gate expository on the tax dispute management system and procedure in Nigeria. We're very, very grateful to you. I have the firm I work for has a tax appeal tribunal case in Ibadan, and I'm immediately going to look for your book and also get the slides from the organizers for it to become a reference point. So thank you so much, sir, for this. Gentlemen, you can just further, please put in your questions. Mr. Lasisi Phillips will be here with us until the end of this presentation. Where we'll now be going immediately now to the presentation from Dr. Jerome Okoro. Dr. Jerome Okoro, I've already read his profile, and we'll now be hearing from him, and he'll be exploring tax compliance and enforcement from both the regulatory and the taxpayer's perspective. Dr. Jerome, sir, we'll bring up your slides now, and you have the floor. Dr. Jerome, sir. Thank you so much for having stayed this long to be a part of this. Please, sir, you have the next 45 minutes to take us through. We use the last bit of this presentation for question and answers. Sir, you have the floor. Thank you so much.
Thank you very much. I may consider it an uphill task to present so much within so short a time, but I'll do my very best to make it downhill, to bring it downhill. Thank you very much. I want to be reassured of my audience. If I have the audience of participants, am I being heard?
Yes, you're being heard loud and clear. We have over 1,000 attendees on Zoom and close to 500 on YouTube that are already hearing you, sir. So please, sir, go ahead.
Thank you very much. Tax compliance and enforcement under the new tax regime is very broad in context. We are going to take hindsight and also relate it to what we have now, and then how we are going to a very crucial role of consultants, of legal practitioners like us, as the guides, the people that show the way to compliance and enforcement. There is an outline to guide the presentation, presenting a summary of what we are going to be discussing. So we'll take a quick look at that and move on to the introduction. As a brief opening remark, it's no longer news that the federal government embarked on the sweeping legal reforms, betting the Tax Reform Act of 2025. Significant changes are made, and that includes the copious areas of compliance and enforcement, what you have to do in order to stay out of trouble with the law. So talking about hindsight, what was the law before now in respect of tax compliance? What did the law say, and what was the source of the law? Before the regime of the new tax laws was the Federal Inland Revenue Service Establishment Act 2007, which made all-encompassing provisions in respect of compliance and enforcement, tax administration, the administration powers of the tax authorities, the compliance duties of taxpayers, and enforcement by the tax authority. This law, you have in its first schedule all the laws administered by the Federal Inland Revenue Service, and where the Federal Inland Revenue Service shared administration authority with the state revenue services, like personal income tax, even though it's a federal law. But then the federal government and the state government shared taxing powers under the PIT. And so it gave powers to both authorities. And then you have the other laws, Companies Income Tax Act, Personal Income Tax Act, as you mentioned, PITA, that is, PPTA, the Petroleum Profit Tax Act, and the Value Added Tax Act, all in the first schedule. And so all these laws were put together in the FIRS Establishment Act as laws administered by the tax authorities. The compliance duties and enforcement powers and procedures were contained in these laws, but there were general provisions in the FIRS Act 2007. But the FIRS Act superseded these other laws in respect of compliance, in respect of enforcement, in respect of the consequences of non-compliance, penalties, and interest liabilities. That was the law before the new tax acts came on board. Now, under the new era, tax compliance procedures and then administration and enforcement are now consolidated. They are harmonized in the Nigerian Tax Administration Act, that is the NTAA. It has copious provisions on what taxpayers are to do, the procedure of complying, enforcement powers, consequences of non-compliance. You will still find traces in the NTA, that is the Nigerian Tax Act. Then subsidiary legislation. Some confusion arises here. There are a lot of subsidiary legislation that guide compliance because substantive laws provide powers, they provide rights and duties. But the procedure to comply, the procedure of exercising those powers, the consequences of non-compliance, they are in the substantive law. So the big question is, now that the acts have been enacted, passed into law, have been enacted, the NTA, the NTAA, the Joint Revenue Board Establishment Act, and the Nigerian Revenue Service Act. Now they are there as the substantive laws. What has become the fate of the subsidiary legislation? The circulars, plethora of circulars, guidelines, and explanatory notes, and the regulations. Well, the pre-existing subsidiary legislations made pursuant to those repealed laws, even though the laws have been repealed, they are still operative. Subsidiary legislation are still operative, except where the subsidiary legislation is expressly repealed under the new laws. But if not so repealed, then it will operate under the new laws as though they were made under the new laws. But then, of course, when there is a conflict between a subsidiary legislation and the substantive law overrides, supersedes. So the self-assessment regulation 2011, which of course mostly guide compliance regulation 2018, the withholding tax regulation 2024, very recent, they are still operating. The ones revoked is the value-added tax modification order that's expressly revoked. You don't refer to it again. Some are amended, like the significant order.
Recording in progress.
Sorry, can you My sincere apologies, please.
Move the slides a little bit back. Okay, thank you very much. My apologies once again. All right, we come to the mode of compliance. It's the digital era, and the tax authorities are not left out in the trend. Of course, Tax Promas is in place. That is the digital portal of the Federal Inland Revenue Service, and it continues in operation. That is the platform where tax registration, the processing of generation of tax receipts, filing of returns, a crucial compliance duty. The tax clearance certificate, you process your tax clearance certificate under the portal, the Tax Promas, and that makes it easy, so that in the convenience of your office, you can do all these you can carry out all these compliance duties. The obtaining of taxpayers identification number, known as simply called a tax ID, that is tax identification, is automatic upon incorporation of companies. From the portal of the Corporate Affairs Commission, you will download your certificate of incorporation as an incorporated company, and the TIN is imputed in it. Then there is the provision under the new laws, that precisely Section 23 of the NTAA on VAT fiscalization. But then we expect regulations on that. It's going to create a system of electronic fiscal processing of value-added tax. Email correspondences, even communication with the tax authorities is allowed to be by email, and that was illustrated in the case of Earth Moving International Limited and FIRS. So you can send your notice of objection by email. It has been endorsed, judicially endorsed. You can communicate with the tax authority by email. You can write the letters but not your returns, which would have to follow a specific procedure. But if you are communicating with a tax authority, which is a public body, you make sure you keep record of that communication. Of course, we know in tendering evidence, even though the Evidence Act is limited in the Tax Appeal Tribunal, you don't follow it strictly. But then it's important to keep records. Please move on. There is direct compliance by the taxpayer. Direct compliance by the taxpayer or professional representation. That's talking about how you will relate with the tax authority. You can relate by yourself as a taxpayer. The company, through its tax representative, tax officers like the accountant, or the taxpayer by himself directly, or through a professional agent. But there are specified professional agents that can represent the taxpayer before the tax authority in respect of compliance, like filing of returns. And the professional bodies are stated there: Association of National Accountants, ANAN, CITN, ICANN, that is Institute of Chartered Accountants. You have to be accredited by these bodies if you are going to render tax services before the tax authorities. For lawyers, as legal practitioners, we are not included here, except if in addition to your qualification as a lawyer, you also hold the qualification of one or more of these other professional bodies. But then there is a provision requiring the tax authorities to also accredit professionals that can act as agents. That's Section 33 of the NTAA. Perhaps when they release a regulation, or when this session becomes implemented, they may include legal practitioners. But because it's mostly figures and some technical areas that is the qualification of these bodies is required, then it's necessary that you, as a lawyer intending to be a professional agent before tax authorities, would hold these other qualifications. in order to render tax services. Next slide, please. Key compliance duties. What are the basic duties that you are going to ensure you carry out in order to be at ease with the tax laws? First of all, and foremost, is tax registration. You need to be identified. You need to be captured in the tax net. That is by registering with the tax authority in respect of the relevant taxes and obtaining your tax ID. For Federal Inland Revenue Service, as I said, they've created the tax promas, so that makes it very easy. Then the tax payments, and for value-added tax is for both registered businesses or unregistered businesses. That is, businesses that are not registered. Those that are just doing business, but they are within the threshold for compliance in respect of value-added tax. So you will not say that you are not liable to any tax, to income tax that is under the jurisdiction of the NRS. That is the replacing body of the Federal Inland Revenue Service. If you are a business and you are within the threshold for remittance of value-added tax, you need to register for value-added tax. Now, tax payment and remittance. The tax payment itself is by payment of the tax, the direct payment of the tax by the taxable person. But remittance is by the agent. In respect of value-added tax, of course, is the agent in respect of VAT, because VAT is not the supplier's tax, it is rather the consumer's tax. So the supplier remits. Payee in the regime of personal income tax, it is the employer that remits on behalf of the employee. So payments and remittance, it goes together with returns, because under the self-assessment regime, you will pay the tax first, compute the tax correctly, you pay it, and when you file your returns, you will indicate the tax paid and also include evidence of payment in the returns that is filed. Then the statutory filing, the annual returns. In respect of income tax, there is annual returns. You have the tax year for companies' income tax and the assessment year. For companies' income tax, the tax year is the year of account when the tax is incurred ending on the 31st of December, but the tax is paid on preceding year basis. So it is the subsequent year that you pay the tax for the previous year. And the subsequent year, being the year of assessment, is until the 31st of June. That is 6 months after the end of the accounting year. So within that period, you file annual returns and you must have paid the company's income tax. Likewise, personal income tax, there is the direct assessment in respect of PIT for the self-employed and the unemployed who are earning income that is liable to personal income tax. Those ones you pay as well. The period of compliance, that's the time of assessment, is the first month, that is from the end of the previous year, it's also on preceding year basis, till the 31st of January of the subsequent year. That is when you pay the tax and show evidence of payment. But in respect, filing in respect of remittances, value-added tax, and payee for employees and withholding tax is on monthly basis. For each of these, you will pay and file on the subsequent month after the month that the tax was incurred. For VAT, is the 21st day of the subsequent month. For payee, is on or before the 10th day of the subsequent month. And for withholding tax, on or before the 21st day of the subsequent month. There is quarterly returns, tax incentive returns, and tax planning disclosure. We are going to see these things in details as we move on. Next is who should comply. Who should comply? The duty of compliance. Who does it fall on in respect of the various taxes? So we'll see it under the various tax heads. We see the duty of who should comply, and then the various compliance duties like registration, the filing of payment, and the filing of returns. as we have mentioned. So we come to companies' income tax to elaborately view it. Companies' income tax in respect of registration. Every company, including a company granted exemption, a company not liable to pay tax, is under duty, is under obligation to file self-assessment returns with the Nigerian Revenue Service. What are we saying here? And we need to note this point because it's very important. Exemption from companies' income tax does not mean exemption from filing returns. It doesn't mean exemption from registration or filing of returns. And that has been the law under Section 55 of the Companies Income Tax Act, which has now been repealed. It is written here. Whether you are exempted as a small company, of course, we see the exempted categories of companies. The small companies under Section 202 of the Nigerian Tax Act, the NTA, that is companies earning gross annual turnover of 50 million naira or less. That's 50 million naira inclusive, and less than 50 million naira. Those ones are exempted, but exemption is from payment of tax. And with total fixed asset not exceeding 250 million naira, that's about the same thing. All these companies are still liable to register, get their tax ID, and file their returns, because it is from the filing of returns that the status of the company as an exempted company or as a small company is ascertained, and that status is not permanent. A small company in a year can be a big company liable to payment of tax in another year. Self-assessment, as I said, it entails the taxpayer by itself, in this case the company, correctly computing the tax as outlined in the law. It has to determine its total profit from all sources. A Nigerian company is taxed on its global income. Wherever the income is derived, it is liable to tax in Nigeria. It computes it, deducts the allowable expenses, the allowances, and then pays its tax correctly. Then after paying the tax correctly, within the time, the due date for the filing of returns, it files its returns in the specified particulars, including the evidence of payment of the tax. Self-assessment regulations has made these provisions for compliance, and as I said, that self-assessment regulation is still effective now. The accounting year, we've talked about the accounting year, when it ends for the company, and then the compliance year, the year of assessment, that is on or before the 30th of June of the subsequent year. Accounting year ends on the 31st of December. So for all activities, all income earned in the year 2025, the year to comply, to pay and file returns is from January to the 30th of June of 2026. That's the due date for filing. For old company, we see that is between an old company and a new company is that an old company, the accounting year clearly ends on the 31st of December, and then the subsequent 6 months ending on the 30th of June makes up the 18 months. But for a new company, the 18 months, it doesn't have an order. It's straight 18 months from the time of the incorporation. Non-resident companies deriving income from Nigeria, they are also liable to compliance, that is payment of tax. Those ones are usually assessed on deemed profit basis, because they are assessed based on turnover that is attributable to Nigeria. The condition of taxing a non-resident company based on its income from Nigeria is to the extent that it earns income through a permanent establishment in Nigeria, or it has significant economic presence in Nigeria under the significant economic presence order, but they are liable to filing returns. Controversies arose in respect of deemed profit, because by the assessment of deemed profit, there was a percentage, 80%, that is excluded as allowable expenses, and then 20% subjected to the 30% tax, leading to 6%. But when several cases arose from that, like TSKJ Constructors, Sedco Forest, VF Worldwide, and the rest of them, some of the cases I was involved in, then the Federal Inland Revenue Service started mandatorily enforcing Section 55 of the CITA, that you must compute your income, your actual profit, and file returns based on actual profit and not based on deemed profit of 20%. Let's go on, please. Particulars of the CIT returns is there. A duly completed self-assessment form, audited financial statements. But for a small company, it may just include a statement of account in place of audited financial statement. I say small company here in reiteration of the point earlier made that exemption from tax payment is not exemption from filing of returns. It is mandatory to file returns, both small companies and other exempted companies. The returns include evidence of payment and then the computation of the effective rate or any additional tax that is payable, and attestation. The key officer of the company must attest to the accuracy of what has been filed, because there is a consequence not just for failure to file returns, but for the deliberate filing of inaccurate returns. If you misstate your income, or if you provide information that's not accurate, there is a penalty for it. Now, corporate joint venture. This structure of companies, that's joint venture arrangements or partnerships, companies collaborating and a structure and earning income. If in such arrangement, they incorporate a special purpose vehicle, there is a distinct entity that is running the business and making profit, and what the partner companies or the joint venture parties are earning is their dividend from their shares in the company. Then the compliance lies on the special purpose vehicle or the distinct company that is incorporated. But if they stay just as corporate partners or as joint venture parties, then their compliance, tax payments, tax filing, registration, everything will still have to be distinct, as though there was their income is based on what is derived from that partnership. So it does not affect compliance. They only specify the income as they earned it and as individual parties in respect of that arrangement. Next slide, please. We move to individual income tax or personal income tax is referred to, mostly referred to as individual taxation under the new tax acts. These are the basis of individual income. So it's very, very broad for payee, employment income from salaries, wages, but then income you earn from fees based on services you rendered, and then compensations and bonuses. And so employment income and non-employment income is there, determining who is liable to personal income tax, and you comply accordingly. Next slide. We see exempted categories. The same law, the same rule applicable in the case of companies' income tax in respect of registration and filing and having a tax ID also applies to individual taxes. So the categories that are exempted, like the minimum wage earners, they're exempted from personal income tax. And those earning income, annual income of 800,000 naira or less, they are exempted. But you have to comply. You have to get your tax ID. Returns are still filed, because you will need you will need, apart from other consequences of non-compliance, you will need your tax clearance certificate in respect of government contracts. You will need your TCC in respect of perfection of title to property. That is why compliance is very, very crucial. So there can be direct assessment for the self-employed, as we said, or those earning non-employment income. There is the annual returns or annual compliance, and then for the employees, monthly compliance, which compliance is on the head of the employer who makes monthly payment and files monthly returns on the 10th, on or before the 10th of the subsequent month. But for the self-employed, it is annual. Particulars of returns is there. The duly completed self-assessment form, amount of income from every source. So it is very, very broad in category what you include in your personal income tax computation. Audited financial statement. But if the audited financial statement is only in respect of income earned from a trade or a business, if it is other income that is not from trade or business, there are some income that is not from a regular trade, business, or profession or vocation. You don't need an audited financial statement in that respect. Evidence of payment, and then the gross emolument in respect of payee. Controversy has often arisen when a tax authority demands for nationwide payroll in respect of payee. And then the issue there is, does that state authority have geographical jurisdiction on the income of the other employees who are not residing in the state in respect of the law? And the answer is no. So Tax Appeal Tribunal has resolved this by saying that such information does not come within the authority of the state tax authority. The due date for filing is stated there. Then partnership, compliance in respect of partnership. For a partnership, their compliance is on individual basis. So what is taxed? A partnership is not taxed as an entity. Like you tax a company. No, you don't tax a partnership the same way. Their tax liability is on the individual partners based on their profits from the partnership or remuneration because they are salaried partners or interest on the capital of the partnership. But then this key compliance duty is very crucial in respect of partners. Tax registration of partners, the state tax authority where the principal office of the partnership is, the partners should endeavor to register with the state tax authority where the principal office of the partnership is. And what this registration entails is the provision of the deed of partnership, or if there is no deed of partnership, any agreement or any document specifying the terms of the partnership and then the profit as accruable or the percentage, the equity that is held change. Then within 30 days of that change, the particulars of the change should also be supplied to the tax authority. Consequence of failure to do this registration is that the tax authority can attribute the aggregate, the entire profit of the partnership to the principal partner or to any partner at all that they have information on that partner. They can attribute the entire profit and tax it as income of that partner, or they can evenly distribute the income, the profit of the partnership among all the partners, and that will result in unfairness. Why? Because the profit of the partners is based on their equity holding, and equity holding differs. We'll talk about capital gains tax because capital gains tax is now entwined with income taxes. So for a company, its profit includes chargeable gains, that is gains from the disposal of its assets. that is liable to capital gains tax. Likewise, for individuals, the rate used to be a flat rate. Capital gains tax used to be a flat rate of 10%, but now it conforms with the rate of income taxes. So for companies, the capital gains tax is the 30%, which is the rate for all companies that are liable to companies' income tax. For individuals, the graduated rate of personal income tax, as you have in the schedule to the NTA, is applicable to individuals. So you have from 0% to 25% for individuals. So the compliance for capital gains tax now follows income tax, either companies' income tax or individual tax. Value-added tax. There are categories of value-added tax. Value-added tax, as we know, is a consumption tax, though I call it a supply tax because once supply takes place, value-added tax is incurred. It does not matter what you do with the supply, but then it's just by nomenclature that is called the consumption tax. So it's accruable on all taxable supplies in Nigeria. They are taxed at 7.5%, except those that are expressly exempted, basic food item and the rest of them, a long list of exempted items. And we see the categories of supply that are liable to VAT in three broad classes: goods, services, and the incorporate. For goods, when is it liable to VAT? When it's physically present, imported or assembled in Nigeria, or the beneficial owner is in Nigeria and the right is exercisable in Nigeria or registered in Nigeria. For services, we see when it's liable to VAT in Nigeria, when the person providing when the people consuming the service are in Nigeria. I am rendering the service now. If it's paid for and I'm here rendering the service and you are receiving it as liable to VAT. If I'm here rendering the service and you are outside the shores of Nigeria, you are in Johannesburg, you are in London, any other place apart from Nigeria, it is exported service, then it's not liable to value-added tax. If I'm also outside Nigeria, and is liable to value-added tax in Nigeria. The incorporeal is included. Before, it was not so. That case of SINUC and FIRS was the assessment of value-added tax on the sale of OML. And so the court could not place the category that the OML fell, whether it was a service, whether it was goods, and incorporate was not included. It was under the Finance Act 2020, precisely Section 40 of the Finance Act 2020, that intangibles were brought under value-added tax. So if the right is exploited in Nigeria or registered in Nigeria, or is or connected to a tangible or immovable asset in Nigeria, is liable to value-added tax here. Compliance threshold. So there are businesses, a certain threshold that a business would meet for it to be liable to charge and remit VAT and file VAT returns. Section 147 of the NTAA is similar to Section 202 of the NTA in respect of determination of a small company for the purpose of exemption from companies' income tax. That is, when the gross annual turnover of the business is 50 million or less, and then the fixed asset is less than 250 million, then that business is exempted from value-added tax compliance. And this exemption is elaborate, both VAT registration, VAT collection, and VAT remittance. But the business so exempted can opt out of that exemption. It can choose to opt out of that exemption. It can take the option of complying. And if it complies, it must comply directly. So it must register it must charge and remit VAT, and it must file VAT returns. VAT fiscalization, that is electronic VAT system, I've talked about it. Regulation is expected on this digital mode of compliance with value-added tax because the NTAA is not elaborate on VAT fiscalization. Do I still have the audience, please?
Yes, you do, sir. The audience are still very much around, so you just have like 2 or 3 minutes to just conclude on this so that we can take
How
few
long more
questions.
do I have, please?
Like 5 minutes, sir, because we
5
have
minutes.
to.
Okay. All right. Thank you. Operation of VAT. I will try to make it. Operation of VAT is by input VAT and output VAT mechanism. Input VAT is simply the VAT you charge as a business. You incur VAT on your raw materials in the course of procuring goods that moves your business on. Output VAT, when you render your service or you sell, you charge VAT alongside your fee or your price. The output VAT, the VAT coming alongside your fee or your price is the output VAT. So the VAT remittance, that what you remit to the tax authority, is the excess of the output VAT over the input VAT. So you deduct your input VAT from your output VAT and remit the difference to the tax authority. When the output VAT is the same with input VAT, so you are deducting the entire input VAT. It is swallowed up, no remittance. If your input VAT is more than your output VAT, you are entitled to VAT return. If you don't understand this, then you will be dashing money. You will be paying money that you'll be paying value-added tax that you have not incurred, because as a business, you are the supplier. You are not liable to value-added tax. Please. Then VAT compliance. Yes, the table there, it illustrates what we have just said, how the VAT remittance duty and then the amount of VAT remittance proceeds from the raw material supplier to the producer and then down to the retailer. At the end of the day, it goes down to the consumer. It's only the consumer that has no output VAT to deduct his input VAT from. So the whole VAT rests on the head of the consumer, and that is where it ends. VAT remittance and returns, the particulars are there. We need not talk about it. And we have talked about the time for compliance, the due date for compliance with VAT, 21st of the subsequent month. It has not changed. That is still what it is under the new law. Tax incentive, the other compliance duties like tax incentive returns. If you are enjoying tax incentive, such tax incentive that reduces your liability, then you are liable to file returns. There are a lot of tax incentives. In respect of Federal Inland Revenue Service, the tax incentive returns is filed with, in respect of a company, sorry, is filed with NRS, Nigerian Revenue Service, but states collect their own tax incentive returns. Then there is the customers' quarterly returns by the banks and financial institutions, stockbrokers, and insurance firms. They are mandated in respect of transactions of 25 million or more for individuals, 100 million or more for companies. If the cumulative transaction for individuals in a month is 25 million cumulative or more, cumulative for a company is 100 million or more, then the bank or the financial institution is liable to file returns with the tax authority. That's with NRS. Then suspension and the registration of taxpayers. There's also tax planning returns if you are involved in tax planning. Then the registration. Do not forget, when a business has ceased, I've entertained several questions like that. I'm no longer in business, or the company is no longer in business. Then what happens? If it is temporary cessation, then the tax authority will have to be notified within 30 days so that that tax ID would be suspended. But if it is permanent cessation, also within 30 days of the cessation, then the tax authority will be notified so that the tax ID would be deregistered. If it's a company is wound up, then it will be deregistered. An individual, in the case of death, the tax ID should not be in circulation, but it is the duty of the taxable person to notify the tax authority. Consequences of non-compliance. Consequences of non-compliance. We have administrative penalties. Then we have criminal penalties for non-compliance. The administrative penalties is to create a statutory rule to avoid a situation where there will be issue of a crime is alleged here, the person has not been convicted, and yet penalty is being enforced. The NTAA empowers the tax authority to enforce the interest and penalty. And what are the interest and penalties? For non-payment of tax, when it is due, the penalty is 10%. But interest, in the case of interest, is not determined. So if the tax is in Naira, if the tax involved is in Naira, it is a prevailing central bank rate. If it's the foreign currency, dollar or any other currency, then it is the overnight, the secured overnight financing rate. It used to be London Interbank offer rate, or the policy as adopted by the central bank. Failure to register. If you are supposed to register and you don't register, for the first month of the failure is 50,000 naira, subsequent month 25,000 naira. Then failure to file returns, 100,000 naira for the first month, 50,000 naira for subsequent month. If you are under duty to withhold that and you fail to withhold it, you are liable to 40% of the amount not withheld. But if you withhold and you don't remit, then the entire amount and 10%. Enforcement in terms of recovery, tax recovery, when tax is due, the basis of enforcement is that the assessment has become final and conclusive. And final and conclusive means that within the 30 days for you to object to the tax assessment or to appeal against it, you did not appeal, or you objected and the objection has been resolved by the administrative mode of the tax authority, or you appealed and the appeal has been finally determined. So the assessment is ripe, is final and conclusive and ripe for enforcement. Other enforcement duties include calling for returns, maybe additional returns. Tax substitution was a power that has been exercised even by the FIRS. That is when a tax is enforced in the hands of or through the person that has custody of funds. Most common are the banks, have custody of the funds belonging to the taxpayer. Then the most controversial now is assignment of tax debt. Tax that is due and is not paid is a debt. So the debt can be assigned to any accredited agent of the tax authority. That is raising a lot of controversy for people who are saying, would the tax authority go to access my bank account and deduct tax from it and just go straight away and take tax from my bank account? The answer is no. The provision on assignment of tax debt, there are a lot of condition precedent. First of all, the tax has become final and conclusive. The tax authority must have exhausted all the legal steps, the demand notice and the rest of them, and then there must be a written notice to the taxpayer involved, and then notifying him of the tax debt and also the person that the debt has been assigned. So we can't go into details. Our familiarity with this compliance notice is very crucial, but then it does not end with the existing substantive laws. Regulations are still expected, like the VAT fiscalization is a regulation that is expected. Most of the returns, like tax planning returns, like tax incentive returns, regulations are expected on that. Thank you very much.
Thank you so much, Dr. Jerome. That was quite deeply educating, and would like to thank you for sharing your depth of your knowledge. We have so many questions. I've gotten the gracious approval of the chairman of the TPTA to extend this session to at least cover as much questions as we have. So we'll look at it first by 5:15. If we're still having some questions, we'll probably take it up to 5:30. So I'd like to start first with Mr. Lasisi Phillips, if you're still here, sir. It's a soft question, and I've received this question from numerous participants in this webinar. They're asking, how can they get your books? Maybe you could give us a quick answer to that before I go into the deep questions on the topics presented. Mr. Lasisi Phillips,
Okay,
yes, sir.
The books are available on Seller. Seller is a platform, so you can get the books there. Of course, you can also contact me. I also have copies, so there can be direct sales.
Okay, thank you so much for that. Since you're already here with us, let me just go to some of the questions that have been directed particularly at you. There's this very interesting one. It says, from your experience as a former Tax Appeal Tribunal chairman, what is the most common compliance failure that you see among Nigerian businesses? Tax failure, that's compliance on taxes, sir.
Compliance failure that I have seen. Most of the times, I think it has to do with record. Record keeping. You'll find that most taxpayers will want to justify their returns by their internal control documents. They don't keep, or they usually will not have third-party documents that are usually preferable when it comes to, substantiating your claims. So you see them bringing their own internal control documents, and we have heard the number of cases that is not sufficient. Keep adequate record. If you go to the filling station, you buy fuel, get the receipt from them. You can snap it and keep it. So it becomes your digital evidence. So you need to keep, that is very important, and then you ensure that transactions are properly narrated. So I think, one of the major failures that I have seen is the fact that records are not usually adequately, kept and or presented before the tribunal.
Okay, just quickly, still with you, sir. Just a question on settlement, that you should please elaborate on instances where settlement is recommended and where settlement is prohibited. I think you touched a little bit on this, but maybe you can just elaborate.
I think I touched it quite quickly. Now, settlement is prohibited in two instances, basically by the provisions of the NTAA. The first one is if it will, promote tax evasion, where the taxpayer intentionally, do you understand, designed engaging in an activity leading to the dispute, and that activity is, designed to evade tax. The law says that settlement should not even be contemplated in that and then where it is desirable to have a judicial clarification on an issue. Some of these provisions that we have now that are recondite, you understand, it will be better if they are pronounced upon by, either the tribunal or the court. Those kind of issues should not be issues that should be settled. So in those two instances, the law says no to settlements. And then the ones that where the law encourages settlement, I think there are about 4 instances where the law encourages settlement. If it is in public interest, the first one is in public interest. So if it is in the public interest that the matter should be settled, then and I give an instance, that's that situation. So if it's in the public interest, you can look at my slide. If it's in public interest, then it's better that that matter is settled. If the cost of litigation compared to the cost of settlement, do you understand, is beneficial, why do you want to go through the whole hog of litigation if you are looking at the cost? Because you must have also the cost implication. And then that litigation can go as far as the Supreme Court. I know there was a case that when we came in, we met that case. And that case went on appeal on an interlocutory matter in 2014. That case is still, out there. Probably, I think maybe it may have gone to the Supreme Court now. Do you understand? So by the time you look at the cost implication, even the value of the money, because Naira depreciates, constantly. You understand? There is time value. So when you look at all of that, then you begin to look at it to say, okay, it might be better, to consider, settlement. And then when you have, under a whistleblower arrangement, if, a settlement will, lead you to discover hidden, tax evasion schemes. There's some people that you enter, you have a negotiation with, and they will expose all of those things. If it's going to lead to the exposure of those kind of things, then it just might be better for you, to settle with that matter. So, those are the instances where, the law encourages settlement.
Most of the other questions that have been asked here are questions which I believe the participants, when they get your slides, they will be able to answer. But I have this it's a recurring question. I think it has been asked on almost all the previous days of this series, but I would love it. And then as soon as you finish, I would love Dr. Jerome to also give his opinion on this. And it is the trending question as a result of the NTAA. That's whether the tax authority can access a taxpayer's bank account without consent using the pay now and argue later rule. What are your views on this so that we'll have some form of perspective? It's a question that is recurring.
I think there are 2 issues that have been lumped in that one question.
Yeah.
Pay now, argue later is a principle of tax that relates essentially to pre-objection or pre-appeal deposit. So to be clear, what exactly we are talking about. Now, under our own rule, the law does not allow for pay now and argue later, because once you object or you appeal, that automatically suspends, collection of taxes. All right? We need to be clear the area that the question is directed at. So if they are talking about pay now and appeal later, I think it's a different thing. Then that aspect of whether the government can actually, put their hand directly into your account to take, to satisfy tax liability. Yes, they can. And I say that, guidedly. Yes, they can, in the sense that Dr. Jerome mentioned, I think while he was talking about, some of the consequences of, non-compliance. I think he talked about the power of the tax authority, to substitute. If your money is with the bank, do you understand, and your tax liability has been established, do you understand? Then the tax authority can ask that third party holding your money, usually your bank, do you understand, to place a hold. In fact, they can ask that money should be transferred. So when you look at it from that angle, it will seem that government can do it, but there are preconditions. Because like he said, that assessment must have become final and conclusive. Because once the assessment has become final and conclusive, and other procedures stipulated under the law have been complied with, then the tax authority can actually ask a third party, particularly your bank, to remit that amount that's standing to your credit to the tax authority. So in that sense, in that context, yes, it will seem so.
So thank you so much, sir. Let me bring on Dr. Jerome now, and for him to answer a couple of questions that were directed to him. Dr. Jerome, sir, there's this question which I believe that you could, I'm quite sure that you must have touched on it in your very detailed presentation. There is a question that's also recalled about 2 or 3 times here. So what rights do taxpayers have during audits and enforcement actions, and how can they assert these rights without escalating conflict? Dr. Jerome, sir.
Okay. During audit and reconciliation, audit, first of all, let's understand the primary purpose of audit. Audit is the returns, the duty to file returns is under self-assessment. The self-assessment regime mandates you to pay the tax correctly and file your returns in the particulars as shown in the slides. But it also gives the tax authority the right to verify your returns. So the essence of audit is just to ensure, for the tax authority to ensure that the returns as filed and the tax as paid is accurate. So you have the right there to provide the documents as requested by the tax authority, and also to question the process that they are doing. Because in audit, if you are talking about audit, there are 2 terms here that we have to distinguish. There is routine audit, and then there is investigation. In routine audit, the time is limited to 6 years, because from routine audit comes additional assessment. Routine audit is the returns you have filed and the tax you have paid, which is disclosed in the return. Is it accurate? If it is not accurate, they raise additional assessment. So the period of it is limited to 6 years. If it's beyond 6 years, then it cannot take place again. But if there is a case of deliberate default, like tax evasion, fraud, or willful default, or neglect, then it becomes investigation. And that investigation, it must conform with fair hearing. In that case, it's no longer routine audit. It is then investigation. They are investigating something that is akin to a crime. And so you are entitled to fair hearing, which means they must specifically state what is the wrong. Is it willful default? Is it neglect? Where did you default? How did you evade tax? So that is it. That one investigation can go beyond the 6 years. So in all cases, if of course, the Constitution, section 36, subsection 6, gives you the right to fair hearing, because the determination or the decision that will be taken affects your civil rights and obligations. So you are entitled to fair hearing in that case. But note the difference between routine audit, that is audit, and investigation. And when audit becomes investigation and the basis. So audit cannot go beyond the period. In all cases, you are entitled to fair hearing. And then to add to the other question about assessing bank account, in tax substitution, you are being placed, the bank is being placed in the position of the taxpayer. This is justified because in all cases, you hear of a big company, even the picture of a conglomerate may be painted, but the whole company is restricted to a portfolio. The owner is not traceable. There is no physical address. So the only way to go after such a company is through the banks, through the bank returns on the customers. And so they will now place the bank in lieu of the taxpayer and serve notice of assessment on the bank. The bank can object. So they enforce the tax in the hands of the taxpayer. That is tax substitution. Then there is also tax debt assignment. Since the tax that is owed and not that is due and not paid is a debt to the government, they can assign that debt to a third party, and that third party becomes the creditor. So in this case, the bank as the agent becomes the creditor. So that's the difference between tax substitution and tax debt assignment, the bank becomes the creditor. And so the creditor can put the bank as custodian of the fund, or the financial institution can dip hands in your account and take the tax from there. People will raise constitutional issues, but there are conditions that are set down in the NTAA, as I've mentioned. The tax must have become final and conclusive. They must have cleared all the legal parts, like even attempted enforcement, but it failed, before they can assign tax debt. And before they finally settle for tax debt and that assignment, they must notify you in writing and tell you the assigned, the accredited creditor, the agent creditor. So that's it. Thank you.
Yeah, thank you so much for that answer. It has really clarified a lot of issues. I'm still staying with you, sir. We have had like 2 or 3 questions on withholding tax and the new rules. So maybe you could shed some light on that. And I'll just take the 2 questions together, and then I think we can close this. The first is there is confusion around whether the withholding tax still applies under the new tax regime. Could you clarify the current position? And then second one, which is also similar, can you explain the most common misconception taxpayers have about withholding tax as a final or advanced tax?
Okay. Under the new tax regime, withholding tax is applicable, and the withholding tax, as I said at the very beginning, the withholding tax regulation, the latest withholding tax regulation 2024, is applicable under the new rules. Why? Because the NTAA, in terms of compliance, saved the pre-existing subsidiary legislation. Regulation is subsidiary legislation. So all the circulars, including withholding tax regulation 2024, is saved under the NTAA. So it's still applicable. So withholding tax is still deducted by the percentages as provided for in the regulations, in respect of rent, in respect of interest, in respect of royalties, in respect of agency fees, in respect of management fees and contractual fees. So it's much applicable under the new rules, and the withholding tax regulation 2024 is still very much in force. And then coming to withholding tax as final tax and as advanced tax. Withholding tax is not a distinct tax. That is misconception that many would have. Withholding tax is income tax. It's either personal income tax or company's income tax. In the case of personal income tax, it's just paid in advance, such that in respect of the transactions that are liable to withholding tax, like if the income is coming by way of rent, the person that is paying the rent to the owner of the income, either company or individual, is deducting the rent and remitting to the relevant tax authority. If his company is NRS, if his individual is the state authority. Likewise, if it is royalty on your intellectual property or your title, if it is interest on your asset, if it is the rent, the person that is paying you is remitting the withholding tax percentage and remitting it to the tax authority where your tax record is. And why he is remitting it, why they are remitting it, they are paying it on your behalf. They are paying it based on your tax record in your tax account, company's income tax. When they remit it and pay it, they obtain from the tax authority what is called withholding tax credit note. This withholding tax credit note is given to you so that when eventually you are to pay your company's income tax or personal income tax, you are offsetting that amount that is already paid in advance. That way, double taxation is saved. Double taxation is saved. But there are some cases that the company, the income of the company ends with the rent. It doesn't earn any other income. It ends with the royalty, or the individual, the income of the individual ends with the royalty, ends with the rent, ends with such income and nothing more. Then that is the final tax. Nothing else is taxed. Then there are also some cases like when a company has investment in another company, has shares in another company, that is corporate investment. On the shares, it earns dividend. Withholding tax is paid on the dividend. When that tax is when the withholding tax is paid upon the deduction, upon this deduction from the dividend at source, it is the final tax because the income that is going to that company by way of dividend is franked investment income. It is known as franked investment income, and so it's not liable to any further tax. That's the meaning of withholding tax as final tax. It's not a distinct tax, it's just income tax paid in advance and paid on finality in certain cases. Thank you very much.
Thank you so much, Dr. Jerome. This is one of the most detailed explanations I've ever had about withholding tax, and very, very clear and very, very, very enlightening. Thank you so much. So, gentlemen, ladies, we would like to say a huge thank you to our speakers today, Mr. Olarinwaju Lasisi Phillips and Dr. Jerome Okoro. The Practical Training Academy says a huge thank you. You have given us your time today and widened our knowledge and given us a lot of gems to take on taxation. Gentlemen, this marks the end of the taxation training series of the Practical Training Academy. And we must say a huge thank you to all the participants that have been here right from Monday to date, 4 days, each time 2 hours. We have full capacity to the very end on each of our training sessions. We must say a huge thank you to everyone that has made this training session worth your while. Again, you get your first CPD points. Again, please go to our YouTube. All the videos of these trainings are uploaded on our YouTube channel, and you can get access to them there. All you have to do is just subscribe to the channel and you can have access to all the videos of our previous training sessions. We must acknowledge the presence of Mrs. Sarah Ajijola. She's the director of the Institute of the NBA ICAE. Thank you so much for being here right from the beginning till now. I also acknowledge the presence of A.A. Baku, who was also of the ICAE who monitored this session. I must convey the gratitude of the chairman of the Practical Training Academy, Mr. Tobena Orojikwe, who has put all of this together. All we have been doing is to provide support for him at the background, and it is all with the essence of increasing the capacity of lawyers in Nigeria. So just to say thank you, and this will mark the physical end of the training sessions for the year 2025 for the Practical Training Academy. Next year promises to be explosive, and we'll be coming back with a bang and giving you all the necessary knowledge that we require to build your practice across board. So once again, on behalf of the Practical Training Academy, we say a huge thank you to our participants and everyone that has joined us, and all our facilitators too, for all the training sessions that we've been able to hold. Thank you so much, and may God bless all of us.